sir. I'm going to need you to move to economy.
What? This is my seat.
First class is for certain tickets. You're in the wrong section.
My boarding pass says 2A. You scanned it.
I don't think this is right. People don't just end up here.
Oh, so you think I can't afford the VIP? Call your supervisor.
Why?
Because you're about to make this real expensive, buddy.
He had purchased that first-class seat 6 weeks before the flight. It had not been an impulsive purchase or a last-minute decision. It had been planned with the advanced preparation of someone who travels frequently enough to know that the price of a first-class seat on certain routes is worth what it costs when the alternative is arriving at an important meeting after 8 hours compressed in an economy-class row. He had chosen the specific seat on the app, had received the confirmation by email, had checked in online the night before, and had arrived at the boarding gate with enough time to board on the first call. He had done everything that any other first-class passenger does when they buy a ticket and intend to use what they paid for. And then a flight attendant appeared beside his seat and asked him to stand up. The phone in his jacket pocket began recording before he had fully processed what was being asked. That reflex, picking up the phone and documenting when something that should not be happening begins to happen, had become common enough among enough people that the world had accumulated over recent years, a growing archive of moments that would otherwise exist only in the memory of those who lived them and in the institutional version of those who caused them. This specific video, recorded in a first-class cabin while the plane was still on the ground, with passengers boarding around it, would become part of that archive in a way the airline had certainly not calculated when the flight attendant made the decision she made. The man sitting in that first-class seat was named Marcus. He was 38 years old, was a senior financial consultant at a firm with offices in 4 countries, and had accumulated over 12 years of career, a level of experience with air travel that most people never develop, because most people do not spend their lives inside airplanes the way he did. He knew boarding protocols, knew passenger rights, knew the difference between a request that has a basis in some operational rule and a request that has no basis beyond the decision of whoever is making it. What the flight attendant had asked him to do, stand up from the seat he had purchased and paid for without any explanation that held up, was clearly the second category. And Marcus knew that with the precision of someone who had spent 12 years learning the difference. The flight attendant had arrived at his seat with that specific posture of institutional authority that exists in uniformed professions, the posture of someone who represents an institution larger than themselves, and who uses that representation as implicit justification for every request they make. She had said there was a problem with his seat. She had not specified what problem. She had said she needed him to stand up while the situation was verified. Marcus had asked for a more specific explanation of what the problem was and what exactly was being verified. The flight attendant had repeated the request without providing the explanation. There were other first-class passengers around them, seated in their seats, with no similar request being made to any of them. Marcus's camera had begun recording at that moment, with the phone positioned in a way that captured the flight attendant, the seat, and the surrounding passengers without it being immediately obvious what was being done. If this is your first time on this channel, welcome. What this story reveals about how certain assumptions operate even in spaces where money should be the only relevant criterion will surprise you, and the outcome has a specific number that the airline had clearly not calculated when everything began. Hit subscribe right now and tell me in the comments, have you ever been treated as though you did not belong in a space you had paid to be in? Tell me down below. Marcus did not stand up from the seat. He stayed where he was with the phone recording discreetly and did something the camera captured and that anyone watching the video would recognize as the movement of someone who knows exactly what they are doing. He reached into his jacket pocket, removed the boarding pass, and placed it on the tray in front of him with the seat number visible to the camera. That simple gesture, showing the boarding pass without being asked, communicated several things simultaneously. It communicated that he had the document proving he was in the correct seat. It communicated that he knew the document existed and was relevant. And it communicated in a way the camera captured with enough clarity to be seen by millions of people in the weeks that followed that the problem with that seat was not the seat. It was who was in it. Marcus had arrived at that airport that morning with the routine of someone who had made that same journey hundreds of times. He knew where long-term parking was, knew which check-in line moved faster in that specific terminal, knew that the coffee shop on the right side after security had a better espresso than anything served on board, and that it was worth the extra 8 minutes it took to buy and walk to the gate. He had done all of this with the quiet efficiency of someone who no longer needs to think about these steps, because he had executed them enough times for them to become automatic. He had arrived at the gate with coffee in hand, had waited for the priority boarding call, had boarded before most other passengers, had reached his seat, 3A, window, left side of the first-class cabin, and had settled in with that familiar feeling of someone who is exactly where they plan to be. The flight attendant who approached his seat during boarding was named according to the badge. Marcus's camera captured with enough resolution to read Jennifer. She had arrived at 3A with an expression that Marcus would later describe in the statement he gave his attorneys as the expression of someone who had already made a decision before opening their mouth. There was no hesitation in the approach. There was none of the body language of someone bringing information that may be uncomfortable, but that has a clear factual basis. There was the posture of someone who had decided what they needed to happen and was communicating that decision in a way that presumed it would be carried out. The first thing she said was that there was an inconsistency in the seating system, and that she needed Marcus to accompany her to the front of the cabin while the situation was resolved. Marcus had asked her to specify which inconsistency. Jennifer had said the system was showing a double allocation for that seat, and that it was standard procedure to move one of the passengers while the situation was verified. Marcus had then asked the most obvious question available at that moment: why he was being asked to move rather than the other passenger who was supposedly also allocated to the same seat. Jennifer had not answered that question directly. She had repeated that it was standard procedure and that she needed him to accompany her. Marcus had looked around the first-class cabin. There were 4 other passengers already seated, all white, none of them being approached. There were 2 seats still empty, including the seat beside his, 3B. And there was one very simple fact that made the double allocation story immediately questionable. If there was a double allocation at 3A, any airline's standard resolution would be to check the boarding passes of both passengers before asking either one to move. Jennifer had not asked for Marcus's boarding pass. She had asked him to stand up. It was at that moment that Marcus removed the boarding pass from his pocket and placed it on the tray. He pointed to the seat number printed on the card, 3A, and then pointed to the number printed on the seat back in front of him, also 3A, and said with a calm the camera captured as the calm of someone being deliberately clear because they want every word to be comprehensible to anyone who watches what is being recorded, that his boarding pass showed he was in the correct seat and that he was willing to wait in the seat while the supposed inconsistency was verified the way any genuine inconsistency would be verified, by consulting the system and the records, not by asking a passenger to stand up without first checking their documents. Jennifer listened to this with the expression she had brought from the beginning, and that had not changed throughout the interaction up to that point. Then she said something Marcus had not anticipated, and that the camera captured with enough clarity that there was no doubt about what had been said. She said there were other passengers waiting, and that his attitude was delaying the boarding process. The word attitude, said with that specific tone that carries a weight that goes beyond its literal meaning, that suggests the problem is not the situation, but the way the person is responding to the situation, that reframes the person exercising their rights as the obstacle rather than the person violating those rights. Marcus had heard variations of that word, said that way enough times throughout his life to immediately recognize what it was being used to do in that moment. He had not responded with anger. He had responded with a question, asking whether Jennifer could call the cabin supervisor because he would like a supervisor to be present while the situation was resolved. That request for supervision had produced in Jennifer's expression a change the camera captured and that anyone watching would describe as the moment it became clear that the situation was moving out of the control she had presumed to have over it. The cabin supervisor arrived 2 minutes later. His name was Robert. He had the kind of posture of someone with more years of service and more experience in the conflict situations with passengers than Jennifer, and he had arrived with the expression of someone who did not yet know what he was walking into, but knew he needed to assess before acting. Marcus explained the situation sequentially and factually, showed the boarding pass, pointed to the seat, and then did something Robert had not anticipated. He turned the phone and showed that a recording had been in progress since the beginning of the interaction, not as a threat, as information. Robert's expression at that moment, captured by the camera Marcus had just revealed was recording, was the second most analyzed moment of the entire video when it became public weeks later. Because it was the expression of someone simultaneously processing what had happened, what was recorded, and what that meant for everything that would happen from that point forward. Robert was silent for perhaps 5 seconds after Marcus revealed the recording. 5 seconds that the camera captured with the ambient sound of the plane in the background, the sound of passengers still boarding through economy class, bags being stowed in overhead compartments, the normalcy of a regular boarding serving as sonic contrast to that pause happening in the first-class cabin. When Robert spoke, the tone had shifted from what Marcus had described of Jennifer's arrival. There was in it a carefulness that was not necessarily empathy, but was the carefulness of someone who understands that every word spoken from that moment forward is being recorded and will need to be defensible. He asked for Marcus's boarding pass. Marcus handed it over. Robert examined it, verified the seat number, and then did something Jennifer had not done at any point in the prior interaction. He checked the system on the tablet he was carrying and confirmed out loud that seat 3A was correctly allocated to Marcus's name. That confirmation, spoken by Robert out loud and captured by the camera with enough clarity to be transcribed, was the logical end of the situation. The seat was correct. The passenger was in the right seat. There was no double allocation. The story that had been used to justify the request for Marcus to stand up had been verified and had turned out to be non-existent. In any reasonable sequence of events, that would have been the moment Robert apologized for the confusion, returned the boarding pass, and continued with the boarding process. But what happened next was not that, and what happened next was what transformed an incident that could have been closed at that moment into a process that would cost the airline a 7-figure amount and produce one of the most watched recordings of the year in that segment of discrimination cases. Jennifer had been standing beside Robert during the verification. When he confirmed that the seat was correctly allocated, she said, something the camera captured, and that Robert had clearly not anticipated she would say at that moment. She said that other passengers had reported feeling uncomfortable with Marcus's presence in the cabin and that the company's protocol allowed for the reallocation of passengers in situations where the comfort and safety of other passengers were a concern. That allegation, that other passengers had reported discomfort, appeared for the first time at that moment of the interaction, had not been mentioned during any of the prior approaches. And there was a very simple reason for that which anyone watching the video would immediately identify. It had been constructed in real time as a response to the fact that the double allocation story had collapsed. It was a second narrative being created at the moment the first one had stopped working. Marcus pointed that out explicitly, and the camera captured every word. He said that the allegation of other passengers' discomfort had not been mentioned at any prior point in the interaction, and asked which passengers specifically had reported that discomfort and when that report had been made. Jennifer did not provide any specific names. She said she could not disclose other passengers' information. Marcus then asked whether Robert could verify whether there was any record in the system of any passenger having made that request before or during boarding, before the initial approach. Robert went to check. Marcus stayed in the seat. The camera kept recording. There were other first-class passengers who could hear that conversation from their seats, and at least 2 of them had turned their heads in the direction of 3A with expressions the camera captured in the background, expressions that were unambiguously the expressions of people who were hearing something that was surprising them. Robert returned 3 minutes later with an expression that had changed perceptibly from the one he had when he left to check. There was in him now something that was not exactly discomfort, but was adjacent to it, the expression of someone who has just found information that makes the situation they are in more complicated than they had imagined when they got involved in it. He said there was no record in the system of any passenger having reported discomfort before or during boarding. He said Marcus's seat was confirmed, and he said, with that verbal carefulness of someone trying to close a situation without explicitly admitting what the situation implied, that Marcus was free to remain in his seat and that he was sorry for the confusion. Jennifer was standing beside him when he said that. The camera captured her expression during those words. It was not the expression of someone who had just understood they had made a mistake. It was the expression of someone who had not yet arrived at that conclusion. What happened in the following 10 minutes was captured by Marcus's camera in fragments, because he had lowered the phone. after Robert's confirmation, but had left the recording active in his pocket, capturing audio of sufficient quality to be relevant. Jennifer had stepped away after Robert's words, but had returned to 3A 2 more times during the remainder of boarding, once under the pretext of checking whether Marcus needed anything, and once with no articulated pretext, simply pausing briefly beside the seat with the posture the camera had captured from the beginning. Each of those interactions had been brief and without additional incident, but the camera had recorded their frequency in a way that Marcus's attorneys would later describe as documentation of a pattern of behavior that went beyond the initial episode, and that was relevant to characterizing what had happened in that cabin as something systematic rather than an isolated moment of poor judgment. The plane landed at Marcus's destination 5 hours and 40 minutes after boarding. During that time, the first-class service had been conducted by Jennifer and a second flight attendant, and the difference between how Marcus had been served and how the other passengers in the same cabin had been served was documentable through the audio the pocket camera had captured intermittently during the flight. It was not a dramatic difference. There was no additional incident that compared to what had happened during boarding. It was a difference in details, in the frequency of check-ins, in the tone of interactions, in the speed with which requests were attended to. It was the kind of difference that each individual passenger experiences subjectively, and that normally leaves no verifiable record. But the camera had captured enough fragments of those details that, when analyzed together, they established a line of continuity between what had happened during boarding and what had continued, happening over the following 5 hours. Marcus had spent part of the flight with his phone on the tray in front of him, open on a document where he had begun recording every detail of the incident, with the precision of someone who knows that memory is fallible and that contemporaneous documentation carries different weight than subsequent reconstruction. He had noted the approximate times of each interaction with Jennifer during boarding, had described the content of each exchange, had noted the names visible on the badges, had documented the absence of any system record confirmed by Robert, and had recorded the 2 additional visits Jennifer had made to his seat after the situation had nominally been resolved. That document, created on board the plane while the details were still immediate, would become one of the most important corroborating pieces of the lawsuit that would develop in the weeks that followed. Because it had been created before any strategic consideration about the case could have influenced what was included or excluded. When the plane landed and passengers began disembarking, Marcus stayed in his seat until most of the other first-class passengers had left. Not out of hesitation. For a specific reason he had decided during the flight. He wanted to document the state of the seat and the surrounding space before leaving, including the boarding pass he had placed on the tray during boarding, and that had remained there visibly throughout the flight. The camera captured that final moment in the cabin, the empty seat beside him, the boarding pass with 3A printed on it, and the first-class cabin, with the specific quality of a space being left behind. It was an image without drama, but with a documentary completeness that Marcus's attorneys would value when the body of evidence was analyzed for the first time. Marcus contacted a law firm specializing in racial discrimination and consumer rights the morning after the flight. He had researched the night. Before, had identified a firm with a specific track record in cases against airlines, and had sent an email at 11 at night with a detailed description of the incident and a direct question about whether there was legal basis for a lawsuit. The response had arrived at 6 the following morning, which was itself an indicator of how the firm had assessed what it had received. The attorney who responded had said she needed to see the recording before making any formal assessment, but that the description Marcus had provided, if corroborated by the video, described a set of facts that fell into multiple categories of violation of federal anti-discrimination legislation applicable to air carriers. The recording was sent that morning. The formal assessment arrived the following day. The attorney had watched the video 3 times, had shared it with 2 colleagues at the firm who had watched it independently, and all had reached the same conclusion. The recording showed a sequence of events that supported with direct and verifiable evidence allegations of racial discrimination in a public transportation service, which was a specific category of legal protection with established jurisprudence and a history of cases that had resulted in significant settlements when the evidence was sufficiently clear. The evidence in this case was, in the firm's assessment, clearer than in most cases they had conducted. The camera had captured the initial approach, had captured the double allocation story being presented without basis, had captured the story of other passengers' discomfort being created in real time after the first had collapsed, and had captured Robert's confirmation that neither narrative had support in the system. It was a documented progression of two false allegations used sequentially to attempt to remove a black passenger from a first-class seat that had been legally purchased and paid for. The airline was formally notified of the intent to sue 15 days after the flight. The notification included a detailed description of the incident, the names of the employees involved as identified in the recording and flight records, and a specific reference to the existence of video material documenting the interaction. There was also a very clear instruction that any attempt to access, alter, or destroy internal records related to the flight, including seat allocation system logs, onboard communications records, and any documentation related to interactions with Marcus during that specific flight, would be treated as obstruction with all applicable legal consequences. The firm had learned in prior cases that airlines have automatic archiving systems that overwrite operational logs in relatively short windows, and that the explicit notification about evidence preservation needed to arrive before those automatic processes created a loss that would afterward be difficult to distinguish from deliberate destruction. The airline responded to the formal notification 12 days after receiving it through a letter signed by the legal department that followed the standard structure of institutional responses to litigation threats: formal acknowledgement of receipt of the notification, declaration of commitment to internal investigation, and language about the company's values regarding equal treatment of all passengers, constructed in a way that sounded like accountability without admitting any specific fact. Marcus's attorney had seen variations of that letter enough times to know what it communicated beyond what was written. The company had assessed the situation enough to understand it needed time before deciding how to respond substantively, and was using the language of internal investigation as a mechanism to create that time without committing to any specific legal position. The lawsuit was filed in federal court 22 days after the notification, when it became clear that the internal investigation the company had promised had not produced any substantive communication, and that the time created by the initial response was being used to build a defense rather than resolve the situation. The filed document was 84 pages long and had been constructed with a specificity that reflected the quality of the available evidence. Each allegation was anchored in a verifiable moment of the recording with specific timestamps and transcriptions of the captured audio. The progression of the two false narratives, first the double allocation and then the discomfort of other passengers, was documented in a way that showed not only that the allegations were false, but that the second had appeared immediately after. The first had been disproved by the company's own supervisor, which established an intent to find any available justification to remove Marcus from the seat, regardless of the factual validity of that justification. The company had done, in the weeks between the notification and the filing of the lawsuit, something that Marcus's attorneys had anticipated but hoped not to have to confront. It had attempted to contact Robert, the cabin supervisor, through internal channels and had held at least one meeting with him that had not been spontaneously disclosed, but had been discovered during the discovery process when internal communications records were formally requested. That meeting had occurred 12 days after Marcus's notification, which was also the same day the company's formal response had been sent. The coincidence of dates had been noted by Marcus's attorneys and had become part of a line of questioning during depositions that produced responses from Robert that were, in the most charitable interpretation, carefully imprecise about the content of what had been discussed in that meeting. Jennifer had been removed from flight duties 2 weeks after the filing of the lawsuit, in a decision the company had described internally as an administrative measure during the investigation, but that had been communicated externally in a way sufficiently ambiguous not to confirm any acknowledgement of responsibility. That ambiguity had been deliberate and had been noted by both Marcus's attorneys and the journalists who had begun following the case after the existence of the video became public knowledge. The recording had reached the press not through any action by Marcus or his attorneys, but through a source close to the case who had shared the video with a reporter who covered cases of racial discrimination in public transportation services. When the video was published, the reaction had been immediate and had followed the pattern that videos of that kind produce when the evidence is sufficiently clear: broad outrage, extensive coverage, and pressure on the company that made each subsequent public statement more difficult to formulate than the previous one. The company had attempted, in the days following the publication of the video, to produce a narrative about the incident that acknowledged what was visible in the recording without admitting discrimination. It had spoken about a communication failure, about procedures that would be revised, about the company's commitment to diversity and inclusion. Each of those statements had been analyzed in parallel with the specific moments of the recording that contradicted the language used, and that analysis had circulated on the same platforms that had amplified the video, creating a layer of public fact-checking that made the company's communication strategy progressively less effective with each attempt. The public that had watched the video had seen Jennifer create a second narrative in real time after the first had collapsed. When the company created public narratives about communication failure, the memory of that specific moment made those narratives difficult to receive without skepticism. Depositions began 6 weeks after the filing of the lawsuit. Jennifer was deposed first, and what was recorded in that session was the kind of testimony that legal practitioners describe as involuntary documentation, because the answers she gave to questions about each specific moment of the recording were systematically inconsistent with what the camera showed in a way that could not be attributed to isolated memory lapses, but that configured a pattern of reconstruction of events that diverged from the recorded evidence at precisely the points most relevant to the lawsuit's central allegations. About the double allocation, she had said she had received the information from a colleague before boarding, but had been unable to identify which colleague or at what specific moment that communication had occurred. About the allegation of other passengers' discomfort, she had said it was her perception, based on the body language of surrounding passengers, which was a completely different version from what she had said during the interaction, when she had stated that passengers had actively reported the discomfort. Each of those inconsistencies was documented by Marcus's recording on one side and by Jennifer's own deposition on the other, and the juxtaposition of the two sources was, in the assessment of the attorneys present, sufficiently clear to dispense with any additional argument about the credibility of the version Jennifer was attempting to construct. The agreement was announced on a Tuesday morning, 4 months and 18 days after that flight. The number that leaked before the official confirmation, and that was confirmed by sources close to the proceedings when the press began reporting, had 7 digits. It was not the highest amount ever paid by an airline in a racial discrimination case, but it was among the most significant of the last decade in that specific category. And what made it notable was not only the amount itself, but the context in which it had been reached. A process that had lasted less than 5 months from filing to agreement, at a speed that indicated the company had assessed the risk of going to trial with that recording as central evidence and had reached a conclusion that made any settlement amount preferable to the potential cost of a jury watching the complete video in a courtroom. Marcus's attorney had negotiated the agreement with a clarity about what was and was not negotiable that she would later describe in an interview with a specialized legal publication as the result of having evidence solid enough not to need to make concessions that would weaken what the case represented beyond the individual client's interest. The financial amount had been discussed with Marcus from the beginning as secondary to the institutional conditions, not because the money did not matter, but because Marcus had been explicit from the first consultation that the outcome he wanted from the process was an outcome that changed something beyond his bank account. He had told his attorney in one of the first meetings that there were people who went through the same experience in that same type of seat on that same type of plane without a camera and without the resources to hire the right firm, and that the process needed to produce something that existed beyond that specific flight. The institutional conditions of the agreement reflected that determination with a specificity that Marcus's attorney had insisted be verifiable and not merely declarative. Jennifer was dismissed as a condition of the agreement, not transferred, not suspended for a fixed period, dismissed, with a notation in her employment record that prevented rehire in any passenger-facing role at airlines that shared the industry's human resources database. Robert received a 90-day suspension without pay and was required to complete a training program on racial bias and on the obligation to intervene when witnessing discriminatory conduct, with documented verification of completion. The company was required to completely revise its seat reallocation protocols, creating a system that required verifiable documentation of any systemic problem before any reallocation request could be made to a passenger. and that automatically recorded each reallocation request with the name of the employee who had made it and the time at which it had been made. That last condition, the automatic recording of reallocation. Requests was the one that passenger rights specialists who followed the agreement described as potentially most impactful in the long term because it created an accountability infrastructure that did not depend on any specific passenger having a camera or having resources to sue the company. Each reallocation request would be recorded with enough information for patterns of discriminatory behavior to be identifiable through data analysis over time, even when no individual incident had sufficient evidence to sustain an isolated lawsuit. It was a systemic change of a nature that individual lawsuits rarely produce, and had been negotiated with the precision of someone who had understood from the beginning that the camera had given Marcus an opportunity that most people do not have, and that using that opportunity to create something larger than an individual settlement was the only proportional response to the responsibility that opportunity created. Marcus issued a public statement on the day the agreement was confirmed. It was short, 5 paragraphs, and had been written by him without attorney involvement in the drafting, although it had been reviewed by them before publication. He did not describe the settlement amount. He did not describe Jennifer or Robert by name. He used no language that suggested personal satisfaction with the outcome beyond the acknowledgement that it was a fair result. What he described, with a clarity that recalled the calm with which he had shown the boarding pass in that cabin months earlier, was what he had learned throughout that process about the difference between cases that produce change and cases that produce only compensation. He had said that difference was not in the severity of the discrimination suffered, because there were people who experienced equally severe or more severe discrimination without a camera and without an attorney. It was in the resources available to transform the experience into evidence, and the evidence into process, and the process into conditions that existed after the process ended. And he had said that as long as that difference existed, every person with access to those resources had a responsibility about how they used them that went beyond their interest in their own case. Seat 3A on that specific plane had been occupied by other passengers in the months between Marcus's flight and the agreement. The company had continued operating that route, that plane had continued flying, and the life of that first-class cabin had continued with the normalcy of spaces where significant incidents happen and leave marks that are not visible on the surface. But there was now, recorded in the company's system by legal obligation resulting from the agreement, a protocol that had not existed before. Marcus sat in that seat and Jennifer appeared beside him with that decision already made. Every reallocation request made from that agreement forward was being recorded with name, time, and documented justification. It was a small change relative to the size of the problem it represented, but it was a real, verifiable change that existed independently of any public attention or media pressure, and that had been created because a man had purchased a first-class seat, had paid what had been asked, and had arrived at the airport with a phone in his pocket and the reflex to press record when something that should not be happening begins to happen.